All right. Hi, this is Curt,
And Brad Pinsky.
and we're here for another edition of Fire Law Roundup for May 2nd of 2026. It's May
March
of
2nd.
March, March
Definitely
2nd,
not
March
May.
2nd. I don't know. I'm
Definitely.
looking at the sunlight outside yeah, March 2nd of 2026. It's already March. I can't believe it.
I know. I know. It's amazing. All right. Well, let's start with, I guess, good news for two people and one I never understood anyway. So we're going to start in San Antonio, where we had third-degree stalking charges, right? Stalking charges brought against the president, a longtime president of the San Antonio Professional Firefighters Association.
Mhm.
Look, it's the right outcome. I'll tell you what he was accused of, but there was no trial. They dropped the charges. They're not going to proceed with the case. No criminal charges remain against him. So what did he do? Well, he was arrested in 24, mid 24, following an investigation into a series of emails and text messages he sent or allegedly sent to several San Antonio Fire Department employees, including the deputy chief. And he purported, I don't know why he did this, but he purported to be an independent investigator, which, he's not really independent, but maybe he was, who knows? And he was allegedly, he purported to be reporting on alleged misconduct, and he warned that negative information would be made public unless the recipients responded, right? So he kind of threatened them in that way. And so they linked it to him. But
Mhm.
again, he got charged with stalking, which is so strange. So, you got to look at their stalking laws. So, their Court of Criminal Appeals held that when an alleged stalking conduct consists solely of communication, such as emails and text, courts conduct an analysis whether the communications constitute true threats as opposed to speech. And here, right, because it could be protected speech.
Mhm.
And it may have been, although there was a threat, but saying that we're going to go public with true information, if it was true, is not, I don't even get stalking at all, right? To me,
I don't
menacing
either.
threats, I don't know where stalking comes from. Stalking, right? So everybody knows is you're following somebody and you won't leave them alone. You're either a peeping Tom into their place or you keep following them place to place.
There's usually a domestic relations connection to
Yeah,
stalking as well, a romantic partner or something of that nature, you know?
and it had, here's the part. I didn't look at every state. I didn't look at their state, but I looked at some states and it says, and you have to relay a fear. You have to put a reasonable person in fear. That's one of the requirements of some states stalking. So maybe they said, oh, your fear. And again, I didn't look at Texas, but I don't know. It seems crazy. But they said, yeah, there's not enough here. It could have been, could be First Amendment protected. So that's kind of gone.
Mhm.
Good news for him. I'm not saying I agree with how he dealt with it, but I don't agree with criminal charges in any event. So then let's just hop to Tennessee.
Wait,
Oh,
wait,
yeah.
wait, wait,
Oh,
wait,
yeah.
wait, 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 because I thought this was interesting in that the Court of Criminal Appeals in Texas had sort of drawn a bright line between speech that is a true threat and speech which is protected by the First Amendment, and that basically the charge of stalking could not be premised upon speech which constitutes protected speech. And I thought that was a kind of an interesting twist on it. There is a line of cases under the First Amendment that talk about what is a true threat, and certainly, but to me, if it's a true threat, it's not a First Amendment protected speech.
Correct.
That
Right.
that goes across the line. So, but my question, and this is relevant to this case here, because this person, the firefighter, was the union president. Is it limited to First Amendment protected speech, or could it
Correct.
extend to other forms of speech, such as number one is whistleblower?
Yep.
Okay, now the facts don't give themselves to whistleblower protection, but it's possible for whistleblower protection to apply where First Amendment doesn't.
I thought it was
Um,
freedom of information. To me, it was a freedom of information request. He should have just coined it that way. He didn't need the threat at the end of it if you don't respond. right? Couldn't he just, wasn't he just requesting information? I mean, that's kind of how I look at it.
That part of it I don't know. But let me kind of
Yeah.
finish my thinking on
Yeah.
this. We can go back to that. But the other thread, which I think is more likely to come up in this kind of a scenario, is speech that's protected by concerted activity protection,
Right.
where you have somebody who's speaking on behalf of the union and bringing, labor concerns forward. And now let's get to what I think is going on here, and I'm just speculating based on my own career. Is that they're going to be appointing a new fire chief, and or they were at the time they were trying to sort of whittle down the list of people who were going to be eligible to be the fire chief, and the union was contacting those people. It's possible maybe the union had a preferential choice. It's possible that maybe the union wanted more information about the backgrounds of some of the people. Now, it looks like the one person that seems to have been named in the at least the news articles was someone who was inside and was already a deputy chief or an interim deputy chief. So it was someone who was sort of moving through the organization, and maybe they wanted her, maybe they didn't want her. We don't know. But still, there's a little bit of concerted activity protection that would attach when a union president in the union engage in certain things. So my question, and it's not answered, is whether or not that First Amendment protected speech might also, or the concept of protected speech cannot be grounds for stalking, might extend beyond the First Amendment to other forms of protected speech.
Sure. If you have a legal right to engage in that speech. But the difference, though, I think was not the request, it was the threat. But here, right, I think that's where things change. However, I just looked up the Texas Penal Code, so which is really strange. It's strange that they would even consider charging. So a person commits, it's long, but a person commits the offense of stalking, right? And I'm going to skip some that don't apply, right? Threatening bodily injury, right? That's not that one. But there's another one that says causes the other person to be placed in fear of. So let's go through this. Bodily injury, no, right? But the next one, to feel harassed. And if I stop there, you'd say, okay, it's harassment, maybe, right? But watch the string of things. Harassed, terrified, intimidated, annoyed. I'm shocked that causing someone to be annoyed could be criminal. Yeah. No way. Alarmed, abused, tormented, embarrassed, or offended, and would cause a reasonable person under the circumstances to fear bodily injury. I mean, it goes on. None of this... and it's just not being annoyed right on its own. It goes on, but being in fear of some harm, there's no bodily harm that was threatened. It was maybe embarrassment and such, but I don't see how it would, not that I'm an expert in anyway in Texas criminal law, but I just don't see it. You're right.
I don't either. I think that, it came out the right way, but I think it's interesting. I think it's important for union officials to understand how they can kind of cross a line with some of the conversations they may have while advocating on behalf of the union in a given scenario. So something that you have to think about. I think there might have been some other charges that could have lied, especially where he's misrepresenting his identity in social media. There are states, and I don't know about Texas, there are states that say if you misrepresent your identity in social media, that could be a criminal offense. So
right, and to go back to your kind of lesson to the union people, you can ask for whatever information, and you can say we need this, we want it, but leave off the tagline of a threat. There's no reason to, I have a line, and people love it or hate it, but I always say, I'm never threatening you. I'm just telling you the inevitable consequences of your actions, right? If you do or don't do this, this is what is going to happen. I'm not threatening. This is my next course of action. You shouldn't ever threaten someone.
And that brings us to the proximity of this to extortion and blackmail. Okay. And there's a nexus there. And I think it's really important. They hammered this into us in law school and even continuing legal ed, they hammered into us, is that you can always threaten a civil suit. There is no problem threatening somebody with a civil suit. Right. There is no problem threatening somebody to do something legal.
Right.
But when you try to use a threat to get somebody to do something they are not legally obligated already to do, that can be extortion.
Right. And that would have been a better charge, extortion or menacing, I suppose, right?
Yeah.
Threatening some sort of, but stalking seems very strange. But
Yeah. I
um,
agree. I agree.
anyway, but okay. So, but I think the lesson you point out is right. Just if you're going to do something you have the right to do it. Leave off the
Right.
threat, right? You know, and people who have threats
Other
don't need
than a
to
threat
threaten
of
people.
suit, you're going to be sued. You can always threaten, and that's why I don't want people to come away that you can't make threats. You can make threats, but it's got to be limited to the threat to sue you,
To,
that we will be suing you.
or said another way, to take action you're legally entitled to do.
Right.
I think
Right.
any action you're legally entitled to. I'm going to go to the paper. You have all those rights. Sure. But, and the better line, which attorneys use is, or we will exercise all rights available to us under the law, right? That's our standard line. Why not just do that? Right. Okay. In any event, I think one that deserves a little
Also,
less.
without further notice.
Right. Exactly. Suddenly our threat becomes like 10 pages of, yeah. Okay. Then we go to Tennessee where we have another firefighter case. It's funny how you kind of get these paired up. But we had a firefighter that you and I reported on last year. I think he was charged with criminal impersonation. Now I got to tell you, I think he should have been charged and he probably should have been convicted, but he's charged with criminal impersonation, reckless driving, violation of the emergency light statute after a reported road rage incident back in December of 24. Allegedly, right? It's allegedly this 22-year-old individual followed another driver on a highway, flipped on his lights and a siren on his personal vehicle, flashed what appeared to be a badge, and used a radio in a manner, right, which shows, oh, I'm doing something official, and which allegedly put the other person in a terrified state, right? I don't know why you'd be terrified, but you know, of if you believed it's a cop, you should be the opposite of terrified, except maybe in some circumstances. In any event, the charges are dismissed, and all the records expunged.
Mhm.
I don't get why, really. I mean, if he
Well,
did it,
maybe then what was reported wasn't actually what happened. That's one of the outcomes. There's also the diversion programs that many states have, which, you know, for first-time offenders, I think is a healthy. I've used that with my clients many times. We have a thing in Rhode Island called filing. So what the judge will do, if the judge is in a good mood, the judge will, on a not guilty file, they'll call it a not guilty filing. The person does not have to plead guilty. So on a not guilty, the judge will file it, which essentially, I mean, back in the day, the judge would literally take the complaint and put it in his bottom drawer for a year. And then you come back a year later and they would dismiss it.
We call that an ACD, an adjournment
Right.
in contemplation of dismissal.
So the other way that this can happen is you plead guilty or nolo, and it gets a 1 year filing. If you have to plead at that point, though, you've already basically, you know, you
Started
basically
the process.
you're guilty, and
Right.
so now the only issue there is what your penalty is going to be. You know
Right.
what the punishment's going to be. So it's possible that that's what it was. Either way, the bottom line is, the kid's off, and hopefully he has a good career, and
But don't do this.
wherever he goes. So.
Right. But people should know, don't do this. And I
don't do
think
this.
the person probably, unless they happen to know him, right? And I forget if they knew each other, but if he didn't know, and I assume not because it's road rage. But here's the thing: this probably did happen, and here's why I think. How do you know you had a radio? How do you know you had a badge? And how do you know you had a siren? And how do you know you had lights if you didn't use them?
Yeah.
Maybe
that's
the
what was
lights you could
reported.
see, but.
Yeah,
Right.
that's what was reported. So I was watching a YouTube video last night. It was really interesting. It was in South Carolina. Maybe I shouldn't have said that, but it was in South Carolina, and an environmental police officer pulled over a pickup truck, and it was horrible. It was absolutely horrible. The pickup truck did absolutely nothing. The officer, they had put a deer out in a field, and so somebody driving by would see the deer. It was a decoy deer, okay?
Oh.
But it was at night, and so the truck slowed down. The person looked at it, and then drove on. And the police officer said, "Oh, I'm going to get this guy. He's got a brand new truck. We're gonna confiscate his truck." And he was thinking, because, yeah, well, what they can do in some states, if you violate some of the game laws, they can confiscate your truck, confiscate your firearm, confiscate this. But
Yeah,
he's
yeah.
saying, we're going to be able to be driving that truck around. And it was on the guy's body cam, you
Oh
know?
boy.
So again, all we know here is that the charges were dismissed. We don't know what the police officer was thinking when he charged him, what was publicly reported. All we know is that the case was dismissed here. And I'm generally supportive of law enforcement. I'm a brother of a
Of
police
course,
officer,
of course.
father of a police
But there
officer.
are
I'm
bad
generally
eggs in
supportive,
every career.
just like it's the same gene pool. We hire from the same gene pool. So things happen. So
Yeah.
case is dismissed, and I think that's about all we can say on that.
Okay. I start with this with you and I, despite being lawyers, are really just news reporters. And I feel like we have editorial discretion in what we say, right? We do as a matter of the First Amendment. This is just our opinions on all these things.
Right.
So this one kind of bothers me at this point. We're going to talk about the Los Angeles fire chief, former fire chief, who's now, and I think I'm correct, yet another lawsuit.
Well, we talked about her filing a complaint. She filed a civil complaint, and she's also appealing it through the civil service system, or whatever their internal grievance system is about her demotion.
Okay.
So there's a couple of legal proceedings. Also, there's got to be at least 30 or 40, if not more, civil suits arising out of that Palisades fire.
Oh, sure. Sure.
So there's that one incident has just sparked so much litigation.
Well, here's the short. My opinions on this are not short, and I'm a little confused, which I'll express. But here's generally what happened. So she alleged she's been removed from her position. Right? She's suing the city of Los Angeles. She's alleged she's been removed of her position for retaliation for speaking out about budget cuts and then the impact it had during the Palisades fire. I'll go on before I share my opinion. I'm trying to really bite my tongue here for a second. So look, she's a 26-year veteran of the fire department, right? She's been fire chief from March of 22 to February of 25, a huge department, very good department, right? That's a big deal. But she's suing him for retaliation. And in short, what she says is, the mayor cut the budget, trying to cut 70 some odd positions. It was actually 60 some odd positions or something that were cut, and millions of dollars. And look, California's in crisis. I'll keep my political thoughts to myself, but California's in crisis.
Self-inflicted.
Yeah, self-inflicted, of course. So the mayor wants to cut. Karen Bass wanted to cut 23 million out and eliminate 71 firefighter positions. Then comes the Palisades fire, where they needed a huge amount of firefighters, and the mayor is out of town when it happens. And this apparently is the fire chief's opening, in her eyes, to start berating publicly her boss, the mayor, and the city. Maybe this is where my opinions are coming out. And ultimately, they probably do. They demote her and retaliate her, I'm presuming, for exactly what she said. But, right? And so I just want to focus on retaliation for attacking your boss. That is not protected. Now, she doesn't appear to claim whistleblower, and this really isn't a whistleblower issue, right? Just talking about budget cuts and how it's going to affect us. But you attack the city, you attack your employer, you attack the mayor, and I'm sorry, honorable as it is, right? I have done the same thing, and you will suffer the consequences. But there's no legal protection about, you being demoted, and she was demoted 3 steps down, right? That's a big drop. She's demoted for attacking her boss. So she's suing based on retaliation. Now, look, California is so employee friendly. Maybe there's something there, but I'm just scratching my head coming to, wait a minute, you're attacking her for a budget cut, arguably a necessary evil, right? And with their financial crisis, you attack them for cutting your budget, which I get it. You might have private words with your employer, but you stand by them and say, it's unfortunate we have to do that, but you don't attack your boss. I'd fire you too. And And she's also saying some due process. That's a different issue. I don't know what due process, right? I don't think we know what she had that she deserved, but I don't know, Curt, you attack your boss, you get demoted.
Yeah, and I think there's a difference between confidential employees and ordinary employees. And certain people in organizations, I'm not that familiar with the organization in Los Angeles, but you get a place like Boston or New York, and I think Chicago the same. They have fire commissioners, and then below the fire commissioner, they also have a fire chief. And the loyalty to the administration, in this case the mayor, is at the commissioner level. And the fire chief certainly is, has a certain level of expectation of loyalty. But when you have that commissioner there, the commissioner is really the one that is running political interference, if political interference is to be run.
Yeah.
So I'm not sure of the exact chain of command, whether or not the fire chief reports directly to the mayor or there's some other commission. But I think at some point there's a question of, are you loyal to the taxpayers or are you loyal to the mayor? And I think usually the fire commissioner is loyal to the mayor. The fire chief needs to be loyal to the taxpayers. And now that's a two-edged sword. Just because you're truthful,
right?
Right? You come out and truthful, and now all of a sudden you're going to get inundated with lawsuits because you gave truthful information, which then in turn hurts the organization because you were truthful. So, there's a little bit of dexterity that the chief has got to have there to not unnecessarily encourage civil suits against the city. And I think that's one of the things that has happened here, and that infighting certainly contributed to some of the lawsuits that we're seeing.
And look, she does claim, well, two things. One is continued retaliation, which to me, you piss someone off, they're going to keep retaliating against you. And if they have the right to do that, then or the ability, then they have the right to do that. But she does also say that there's a series of false allegations against her. Now, right. There are two legal states to go one of two ways on this. Some states, you can't sue your employer for defamation. In the employment context. We had a case, it was a disciplinary case. Tort immunity?
The workers' comp immunity?
I'm not sure what it is, but you and I even had a case about 5 months ago. I don't think, maybe it was a New York case out of Nassau County, but it was a case where they tried to sue for defamation based on discipline, right? And part of the disciplinary process.
Oh, okay.
And, so I don't know. But there are definitely, because I know there are definitely some states that say you just can't sue your employer for, in the employment context, saying things that weren't true. It's different when they accuse you of a crime, right? Oh, they're stealing funds. There, of course, you could sue your employer, but things like you weren't doing your job adequately. Well, that's an opinion. That's their evaluation. It's not defamatory. It may be hurtful to you, but their opinion of how you're acting. So I don't know. But she's suing for false accusations. I don't know what specifically those accusations are, but it is tough to win against an employer on saying false accusations. So I'm just saying she has a very uphill road. But the neat thing about how you put this together is the next case is so similar, but totally different. So I like going to that case. And now what I'd like to do. Yeah.
This stuff writes itself. There's no creativity on my part. So
I get it. So maybe you're just lucky. But so I with all of what I just said in mind, right? And then this one we should really spend some good time on. And I'll slow down on the facts. Now we're going to go to Oregon, not so far. And they make great wine. So we're going to go to Oregon, where we have a former employee who, again, alleging retaliation and also a due process violation. So here, now we have an administrative employee. She alleges she was terminated after raising concerns about financial practices. Sounds very familiar if you compare it, right? And certain record keeping. And so she claims that the chief told her there were two sets of books, one that shows the fire department had exceeded its budget by more than $40,000. She says she objected to that two sets of books. She said one is falsified, and she accused them of destroying other records. I think there were safety records, which shocks me if that was true. But in any event, whether it shocks me or not doesn't matter. So she says she reported to a division chief, and then that 1 month later, so that was January of 05, then in February of 25, January of 25, there was reported in February 25. Now she's placed on administrative leave, very close in proximity, which is what courts look to for retaliation, how close, right? And so she had made these allegations that, I think there's false books and something's happening. In late February of 25, there are photographs that documented charges that substantiate it and talk about shredding of documents. Even after she was on leave, I'm not sure where those photographs came from, but it seems to allegedly substantiates her claims. Then there was a termination hearing, and she claimed she wasn't given due process and she was terminated. Now, why is this different, right? For the viewers, why is this different? It may have the same retaliation, but here she reported something that was illegal as opposed to, just a discretionary decision that was made by a city to protect or deal with its finances, right? Destroying records and lying about finances is very different than, right, just saying, well, we had to cut the budget and I disagree with your decision. So almost the exact same allegations, except they're totally different from each other.
Yeah. And also she's not I would imagine she's not a confidential employee either.
No,
so,
right. Administrative.
So that's another factor here. So yeah, the allegations are concerning. So again, it's one of those things we don't know whether her version of the events is accurate or the department's is going to be, but certainly is troubling that things were destroyed or things were deleted if in fact that did happen.
I thought about this. First, I'm thinking, how does she get photographs of records being shredded? And then, by the way, if I walk 5 feet over and start shredding documents and turn my camera to it, you can't read the documents. You have no idea what I'm shredding. So I'm really curious, what proof she made. I'm not doubting her. I'm just saying, how do you get that proof that you're destroying improper records? You're allowed to shred documents in accordance with a record retention policy, but how do you... anyway, so to me, here's what I'm shocked. She didn't claim whistleblower. At least I didn't see that. It's not reported. She's suing under 1983 for First Amendment retaliation and violations of procedural due process. Just so everyone knows, procedural due process generally just gets you the right due process later. You don't win. You just go back in front of the same people sometimes, or hopefully a different neutral board, right? So you at least get your day in court, which is not a bad thing to get. Everyone wants their day in court, but it's not like you win. Whistleblower is what she should be claiming, and I'm sure Oregon has a whistleblower statute. I don't understand that one.
I think what she's looking for is whistleblower protection through the First Amendment. But I agree with you. I think I'd feel more comfortable arguing a whistleblower on the facts, assuming that there is one that is applicable. So,
Got it.
But many times folks, attorneys, they're sort of under pressure to get something out the door to at least get it filed by a certain date, and then they go back and amend and add in additional allegations once they have fully researched them. So, yeah.
Okay, well, the next one I'm going to express my opinion on, and the answer is the fire department loses.
Really?
I know you're shocked that I would have an opinion. Really. But I realize, because you said it probably 2 years ago, we're just kind of like journalists. And I thought, you know what? We get to have whatever opinion we want and make whatever friends or enemies we do. But this one really does and should bother everybody. And so here's what it is. And it's shocking because it's Baltimore. Another really good countywide department, but this is a city. But all Baltimore, such a good fire department, good EMS system, combination system in some ways. So here's what we got. We simply have, this is so easy to explain, but so hard to justify. We have an Orthodox Jew who requested one of the high holidays off. And there's only a few high holidays in the Jewish religion: Rosh Hashanah, the New Year, Yom Kippur, Day of Atonement. There's not a huge number of them, and that's important for this analysis. He requests that off as well as the Sabbath, And I don't know. He's 20. I think he's younger. I'm not sure, but I don't know how long he's worked there. This is what I'm trying to
I
figure
think it's
out.
only a couple of years, I think.
Yeah, and I don't understand how it's coming up just now, but he says the Sabbath, which is every Friday and to Saturday, right? Sundown Friday to sun up or sundown on sundown Friday to sundown Saturday is the Jewish Sabbath. And he claims that he wanted off, and the city denied it, and but said there are shift swaps. Now, as you could do better than I, or we could do, shift swaps are not an employer. It's an employer decision to allow it, but you got to go get someone to take it. And shift swaps may be an accommodation, but it is not a reasonable accommodation. And I'm going to base this on this U.S. Supreme Court case, which I'm very familiar with, and its predecessors. And she cites the right case, but you can't offer shift swaps as an accommodation when it's the only accommodation. That's my legal opinion anyway. And that was what they said. They said, no, we're not going to give you off. We're not going to change your shifts. We're going to allow you to trade shifts with somebody if you can find someone, and this individual could not. They cite a U.S. Supreme Court case of Groff. It is a very well-known case, and what it says is, for an employer to defend a denial of a religious accommodation under Title VII, the employer has to show, and this is important, the burden of granting an accommodation to the employee would result in a substantial increased cost in relation to the conduct of the business. Now maybe if you can't work Fridays and Saturdays and there's no way to accommodate it, and I want to say this, under the ADA, as we prepare for our ADA lecture, they have a similar test, but telling someone you can only work part of a shift. For example, if you work 24 hours and you say, due to a disability, I can only work 12. The courts have routinely said it is not a reasonable accommodation. In other words, it's an undue hardship to an employer to have to get employees to come in and do half the shift. Here, the question will be, it will be a very good case for the fire service. We won't have an answer for years, I'm sure, because this is going to keep going up the courts unless they settle it. I would settle if I was them. But nonetheless, the question is, but every week, remember, the high holiday is 2-3 times a year, but every Friday and Saturday, I can't work. Well, if I'm on a rotating shift, right, that could be an undue hardship. However, is it real? It's a hardship. Of course it's a hardship, right? I got to deal with your shifts, but is it really an undue hardship? And no way would the courts, to me, come out and say, I'm sorry, somebody can't work because of their religion repeatedly all the time, so you can never hire Orthodox Jews. I mean, that's what this would be. Or you can never, right? I mean, there's no way that holding's coming out, that they're going to say you can never hire somebody who needs to take the Sabbath off. It is a hardship, I admit, to the department, but I don't know that you tell me I'm sure you're involved in scheduling. An undue hardship, you can never get somebody's time in, and maybe you can't, because in my department, we had shifts A, B, C, D, right? And we now they do 24s, but back with me it was a little harder. You do 2 on, right? 2 days, 2 nights, 4 off. 2 days, 2 nights, 4 off. That I don't know if that's all hard. I could probably have sat down with the schedule and figured it out with part-timers or other full-time. I don't know, but so I guess I ask you, is that an undue hardship every weekend, Friday to Saturday, to not be able to?
I think so. Work? Yeah, I would say so. That would be my opinion. I think that expecting the department to schedule everyone around this particular person, and if you've got, let's say you have 8 employees, maybe it's reasonable to kind of work around 8 employees. You got 500 employees, and let's say a handful of them need that accommodation. Some need it for Thursday, some need it for Friday, some need it for Saturday. And then now you got 5,000 employees, and I'm not sure Baltimore's probably got 1,500 or so. Let's say 1,500, and let's say you have 10, and then you have a couple of sharpshooters sitting back going, hey, you know what? I think I want Friday nights off. I think I'm going to go join the Church of Tattoos and Snakes, and that Friday and Saturday nights, and I'm going to, but how do you stop it? So I don't think that putting the burden on the department is reasonable under the circumstances. And I also do question whether or not countries like Israel can function if you have to shut down government on Friday night. And I think most religions that I'm
It's
familiar with
exception.
anyway say that, yes, you're supposed to, but when your job requires you to be there, that is an exception.
So I can
And
talk about that. So
yeah.
in Israel, the Hasidic, although the ultra Orthodox,
Mhm.
they were just ordered to report to military duty for the first time ever. But they generally say we can't, right? We can't touch.
It would seem to me to be a pretty good time to attack Israel if people can't fight.
Right. And there are a lot of ultra Orthodox Jews, but there's a lot of
Yeah.
reasons why they can't. They can't
Yeah.
touch non-married women. They can't touch people who are not their wives. They can't
Mhm.
work on certain days. But in New York and mostly downstate, there's a extremely large ambulance company, and they're one of my clients, so I'm just disclosing. But Hatzola Ambulance,
Mhm.
very large political force as well. But there, Jews can't drive. Orthodox Jews and others who obey the Sabbath laws cannot drive or use electricity on the Sabbath. But they respond to calls. And again, they can't touch unmarried women. They can't touch women who are not their wives. Women who are unmarried can't have other people
Even
touch
for
them.
medical reasons?
But they have the exception. That's
See,
the
that's
thing.
what I'm talking about. Yeah.
But so the question would be, so the reason for the viewers that Curt and I aren't going to come to an answer is because under the Supreme Court's test of undue hardship, it is fact-based to that specific department,
Yeah.
right? So
Yeah.
we would have to know, like I would argue, if there's 1,500 employees and only 2 need accommodations, it probably isn't going to provide an unreasonable burden.
Mhm.
I don't know, right? But there are going to be facts. There might be facts of how can we put you, right? We can't take you out of your rotational shift. You're on A shift.
Mhm.
What do? You're on A one week, D the other. That doesn't work. So
Mhm.
maybe I just, as a premise, have a hard time saying we're never going to hire Orthodox Jews or anybody who obeys the Sabbath who's in a rotational shift type atmosphere or employment. That to
Yeah.
me is a big leap. I'm having trouble
Yeah.
believing that will happen. But I
Well,
want to see the cases analysis. I mean,
yeah. There's another issue in this case. I don't know if you picked up it's called the self swap.
this the
So, yeah.
trading shifts.
Well, there's the normal shift trade where let's say it's your Sabbath and you say, "Hey, Curt, can you work for me Saturday?" And I
Right.
say, "Sure, I'll work for you." That's a normal swap. As I understand it, as it's explained in the complaint, Baltimore allows a thing called a self swap, which is basically you would call up let's say you're scheduled to work Saturday. You call up the shift commander on Thursday and say, "Hey, I can work tonight," or I can work, maybe call up Wednesday and say, "You know what? I'm available to work Thursday. Please plug me in Thursday and I'll have Saturday off."
Assuming there's an opening.
Yeah,
Right.
and I'm assuming Baltimore is like 90% of the career departments in here that they're running on overtime. That you
Right.
never, you're supposed to have 200 people on duty, and you start out with about 175. So right off the bat, you need 25 overtime slots, and so now that changes your factual question, I think
Yes.
that if the department allows this self-swap, and apparently they allow it for people who have training commitments or other types of commitments, but if they allow that self-swap, it goes to whether or not it's an undue hardship. Because how can it be an undue hardship when this particular person needs a day off, but you allow it for other reasons?
Right.
And there it kind of falls apart. Now, again, highly factual. And my concern as a chief, my concern is if we say yes, you can do this, what is this going to do to the clowns out there? They're going to say, "Hey, yeah, me too. I want to join the Church of
Right.
the Snakes and Tattoos, and I want Fridays
Yep.
off."
Yep.
You know.
Yep. And by the way, for the
So,
viewers, people have done that. People have come up with
oh,
this, especially during COVID. People came up with these cockamamie religions, saying I'm one of them, so I can't do something.
I've
Um,
heard my clients do it, Brad, and I just shake my head. I'm like, "Oh, please,
yeah.
please."
Um, but the courts look whether this is serious. Like we had a case maybe 2 years ago where somebody claimed to have these religious things, but
Mhm.
didn't know what the Quran was, claimed they were Muslim, but didn't know what the Quran was. Remember that one? And so it was all made up. But
Yeah,
I don't know. This is going to be interesting, and every fact can cut 2 ways. But
yeah,
it's factual, 100% factual.
yeah.
To me, if they have a bunch of open shifts, and you could say to the person, fine. There's so many shifts you could take in lieu of Friday, Saturday, and you'll never be denied. That might be a reasonable accommodation.
Funny story. I was not the first attorney on the Providence Fire Department. A guy named John Hawkins was, and he had gone through law school in the 60s and retired shortly after. He became a state legislator. Very famous. Folks in Rhode Island will remember John Hawkins' name. State legislator, really invaluable asset to the fire service in Rhode Island when he was at the state legislature. Okay, but what the department did was they allowed him to work 48 hours on weekends.
Okay.
So he would basically come in Saturday morning, he'd get out Monday morning, and then he'd go to law school. So they created a special shift for him. Now, I'm not saying do that. I'm not, but what I am saying is if you do that for one person,
you can do it for another.
And it doesn't necessarily, obviously, if the person's Sabbath is a Saturday, now you've got to move it to maybe it's Tuesday, Wednesday for 48 hours or whatever it may be. The reason the city did that was it helped them greatly with overtime on the weekends, which is where I don't know if you notice this, but some firefighters tend to get sicker over weekends than they are on like
Friday
a Tuesday.
flu. We went to Friday flu.
It happens. Yeah. But at any rate, but that was an accommodation. But making those kind of accommodations can actually possibly backfire on the department as well. So
no question. Anyway, so factual analysis we're going to see, and I just, my bet is, well, I don't know what my bet is. I would hope they'd resolve this by better accommodations. I'm guessing that's gone away. That right? They've tried, and they're not going to accommodate them. So the only remedy is go to the court. And keep pursuing it. But it'll be a very interesting factual-based discussion. Okay, I'm gonna plead. I have no idea that I do not totally understand this last case. I can start it, but I really need you.
I'm happy to do it.
Yeah,
and,
I hand this off.
This is a follow-on to a number of other lawsuits that have already been filed by I guess you'd say progressive organizations, cities and towns that want to kind of they're making a political statement, I think, more than a legal statement here. But what the allegations are is that under President Trump, the AFG program, the SAFER program, and several other grant programs have prohibited departments from engaging in certain activities which the prior administration had either green-lighted or actively encouraged, and particularly DEI, I guess, oriented things. So at any rate, these communities apparently have embraced that and now are suing the federal government, claiming that the changes to these programs is illegal, is ultra-virus, and basically that they should be allowed to continue doing what they had been doing under the prior administration. So not unlike, we covered a lawsuit just like this probably 3 or 4 months ago, and I see these coming through regularly. These types of lawsuits are coming through. I don't, blog about every one of them, but I want to every once in a while just to know that these lawsuits are still percolating out there.
So, to get into it just a little bit more, so everyone understands Trump's order abolishing DEI, right? Diversity, inclusion, diversity, equity, inclusion, basically says, and the EEOC has now issued a letter reversing course from their prior decades, saying that you cannot use protected classes, race, gender, religion, as a basis to hire or not hire somebody. You cannot have quotas, right? This is very much like the Frank Ricci, New Hartford, U.S. Supreme Court case. It's kind of Trump says this is basically reverse discrimination, and it is. I mean, it may have a valid purpose, but it is discriminating in favor of the discriminated. But he said that ends, and ordered the EEOC and all other agencies to end it. So it's an interesting, as with everything is Trump right now, especially under the War Powers Act coming today or tomorrow, when that vote happens. But it is a question of what can Trump do as the executive as opposed to what Congress must do. FEMA administers a grant program, and they do so pursuant to a statutory authorization, but DEI and such my understanding, I'm not an expert in this, so take everything with a big legal grain of salt. The executive has the ability to talk about that. You don't necessarily need the legislative side to say, we're going to use quotas or not quotas. I think that's, the fact that it comes from the EEOC and such, I think that's the executive who can do that. I'm not aware of any challenges. Doesn't mean there aren't any. I'm just haven't heard anything on the news about challenges to Trump's power to get rid of DEI. Because I think that's where it came from. I think DEI started with an executive
exactly
order.
that lawsuit. This is one of the lawsuits that's challenging that, but the courts haven't ruled on it, and Congress hasn't acted in this area either. So, it's one thing if Congress says you got to do A, B, and C. If you're going to get an AFG grant, that's one thing. But what happened was a prior administration said you've got to do A, B, and C, and now Trump is saying, no, we don't want you doing A, B, and C.
Right.
Okay. And now they're suing. They say, no, we want to do A, B, and C, and we're being unfairly blocked. So again, it's going to be up to the courts. This is not something that Congress has as required. It's something that was an executive decision in the past, and now the executive decision. That's one of the consequences of doing things as an executive instead of doing it through Congress. But Congress can't get out of their own way. They can't agree on, what, is the sun out right now or not? They're choosing to disagree over everything.
And look, not to get political, obviously Trump's causing a lot of questions about what can the president do and not do. Here, however, the president is pretty much in charge of the Department of Justice. There's no way the Department of Justice is going to enforce any DEI. And I was curious, I think Boston and Syracuse's enforcement orders to get to the population, 32% or whatever, their equality to what the population of minorities. I think those expired or were satisfied, but there are some others that were still in place. I'm wondering if those, orders, I forget what they're called.
Consent decrees usually. Consent decrees or hiring orders, but usually consent decrees.
And they started back in some of the 80s and 90s, right?
70s. I got some in the 70s, yeah.
Okay, and right, so those would go away. Usually it's, hey, we've complied, we're equal, we don't need it anymore, and it goes away. But here, the Department of Justice is not going to enforce it. End of story. Not under Trump. So I don't know. I get it, but I think the executive in this case has the power to waive the DEI, especially in the grant programs. It's federally funded. They're executive agencies.
My guess is it's going to be 5, 6, 7, 8 years before this gets determined finally. So,
and if a Democrat's next in office, it's not going to matter anyway because they're going to reinstate DEI. And I don't say that negatively. I'm just saying
it's another reason why Congress needs to get its act together. If Congress can, bridge the divide and reach sort of a consensus on where we need to go, but nobody's in the mood to compromise.
And then it changes with the political wind of who's the executive, and they issue executive orders, and everyone's done it. Obama did it, Clinton did it, right? Yeah. Trump did it originally, and now it's doing it again. But the wind in the law just changes.
I really I think I'm becoming more of a libertarian, and I'm like, if Congress can't get its act together, then you're all out. You're all out. Let's put in a
start over.
Right, senators in Congress, you're all fired. Let's get some new folks in there that can work together.
Yeah. My father was in state senate in New York and had two simple rules. Rule number 1, don't give up the majority. Rule number 2, don't ever mess with rule number 1. And that's how it works. So whatever keeps the majority. But anyway, okay, so that's where we are.
Well, that's it. That's it for another edition of Fire Law Roundup. If you haven't already clicked subscribe and like, please share. Help our algorithm. We're growing. It seems like each week we're adding on more and more, and we really appreciate the support. And that's going to do it for another week of Fire Law Roundup.